The rise of DAO represents a paradigm shift in how organizations are structured and governed. Given their decentralized nature, how do you see the legal framework evolving to accommodate DAO and the challenges that it might present for both creators and participants? And as DAO really grows popularity, they have several challenges. Traditional legal structures, which are often designed for centralized entities, these things that are really evolving the legal framework will need to balance innovation with regulatory compliance. So the question is basically challenges, things, and the legal framework.
Yep. So the main problems is actually can be stressed out by the quote from UkiDAO case with the Commodity and Future Trading Commission, CFTC, in the US. So it says like the document that is published on their website, the document is dedicated to those who believe that they can circumvent the laws by adopting a DAO structure. It is not a negative or positive document, but it just says that even though you are a founder of innovative, technologically new company, organizations that has never been created before, you shall still comply to the regulations that have been created before, even though they are not adjusted very good to blockchain or Web3 world, but CFTC, uh, Security and Exchange Commission, SEC, or any other regulator will still apply those regulations to you. So here we can answer the first question of current legal framework and concerns with which crypto projects face. It is the regulatory requirement to be complied with all the general laws. So it includes, first of all, of course, civil law, corporate law, security law, and any other laws that were existing before. So yeah, we may talk here a little bit more about what is DAO actually. Of course, DAOs is the decentralized autonomous organizations, which are it can be said that are governed by computer algorithm, and all the decisions are written into a blockchain. And here we can see the decentralization, since all the processes are managed by members of such companies, not by some centralized authority of major shareholders. And autonomous because idealistically, most of decisions shall be executed by the corporation itself. We may say that they are executed automatically, but simplifying, it is so. But actually, many scholars, they differentiate automated execution and autonomous organization. These features can be distinct. So talking about that, here we have the main feature of DAOs. It is an organization, which means that there are two or more members, which means that most of regulators, they will view such organization as one that is already existing in the legal frameworks. So these are either the general partnership, if we are talking about entity-less DAOs, or it is a corporation, if the DAO has created some corporation. Therefore, the main problem here is that if DAO opts in to create the DAO as a corporation, it shall adjust its processes to the already existing rules, which is foreseen in, for example, civil codex, if we are talking about continental legal system, or corporate codexes, and it is very hard to actually use any blockchain technologies or automate your execution of decisions because civil law is actually very simple in this case. You shall have the director that will execute your decisions, and everything shall be in writing. Shall be reports and etc. Moreover, if we are talking about the idealistic decentralized autonomous organization that was described by Vitalik Buterin in his works, DAO shall exist on blockchain, but all the corporations actually exist in registers. They are entered into register by regulators, and moreover, all the shareholders, members shall be uh, counted there, and it actually conflicts with anonymity of those shareholders. So yeah, it is very hard to realize the full potential of decentralized autonomous organizations. That is why sometimes we may see the distinction between real DAOs and fake DAOs. Fake DAOs, they are strive to accommodate to those legal frameworks that already exist. Therefore, we have the following situation in different jurisdictions. It is not the regulators who try to accommodate to DAO, but rather DAOs that try to accommodate to the existing regulations. Examples here may be Wyoming LLC DAO, which is actually just an LLC with some adjustments for DAO, like using the blockchain or using tokens as something that gives voting rights. Plus, here we have example of Cayman Islands with their foundations. It's just general foundations, but startups, they can adjust in bylaws, for example, their managing procedures to use such foundations for DAOs, or even the recent Marshall Islands DAOs. We have the law for DAOs, but it is just LLC. It was created on LLC. So we can see such decentralized autonomous organizations as a superstructure that is built up on the already existing rules. And such superstructure can be used fully, entirely, as it was intended before. Therefore, the main concerns with that is that DAOs, it is the DAO that shall accommodate to legal frameworks, but not the legal frameworks shall accommodate to DAOs. And you can see this on those examples that I have mentioned, and in general by the positions of regulators. In my opinion, unless we reach algocracy, it is the government that is governed by algorithm. The idealistical DAO isn't feasible. So unless everything is governed in state by algorithm, unless it is possible to not use some registers but write everything on blockchain, we cannot realize the full potential of DAOs.
How do you see regulators in terms of adoption of the technology in your own perspective?